Hello, everyone. Welcome back to the EU Renew webinar series on Europe and the world. I am Carrie Otterburn of the Leuven Center for Global Governance Studies, and I will be your host and moderator. Today, we are starting up our fall season with Dr. Ivana Damjanovic, who will be discussing her new book, The European Union and International Investment Law Reform, Between Aspirations and Reality, published last year by Cambridge University Press. Ivana is a senior lecturer at the Canberra Law School. Her research is interdisciplinary, encompassing issues of law and politics in the field of international investment and trade, with particular focus on the European Union. Ivana has qualified as a lawyer in Australia and Europe, and previously served for 9 years as a career diplomat for Croatia with diplomatic postings in Europe and Australia. She also worked as a trade advisor for the delegation of the European Union to Australia and research and policy roles for the Ministry of Foreign Affairs of Croatia. Also joining us today as expert discussant is Dr. Matthieu Burnay. One moment, please. I'm having a small technical issue. Okay, apologies. Matthieu is Reader in Global Law at the Queen Mary University of London, where he also serves as Dean for International at the Faculty of Humanities and Social Sciences. He is also an associate researcher at the Leuven Center for Global Governance Studies. His research focuses on global law and governance, the study of political and legal aspects of EU-China relations and global governance, as well as the comparative study of the role of law in Europe and Asia. He regularly advises governments and international organizations on China-related issues. He convenes the China Capability Training Program of the Foreign and Commonwealth Office of the United Kingdom. We'll begin today's webinar with a presentation by Ivana of approximately 30 minutes, and then we'll turn to Matthieu to kick off the discussion by offering some reflections and asking a few questions, to which Ivana will have an opportunity to respond. Then we will turn to questions from you, the audience. So please feel free to send questions for the speakers at any point during the webinar by using the webinar Q&A function. You should see this little button at the bottom of your Zoom window. It says Q&A. I will collect your questions to share with the speakers during the audience Q&A following the presentations. Before we begin, just a few quick words about the EU Renew project. The EU Research and Education Network on Europe and the World, or EU Renew as we call it, is an Erasmus Money network bringing together 19 higher education institutions from Europe, Asia, Africa, and the Americas, with the goal of improving knowledge and enhancing debate on the EU's role in an ever-changing world. On behalf of EU Renew, I would like to thank Ivana and Matthieu for joining us today. It is my great pleasure to pass the floor now to Ivana. You have the floor.
Thank you very much, Carrie, and it's really a pleasure to be part of this webinar series, and thank you very much for inviting me to participate. And yeah, as I mentioned in our earlier chat, it's also these kind of seminars bring kind of Australia closer to Europe, because often we are far away, and but we still have a dedicated group of EU scholars that work on issues like this. And part of my book is part of a project which I have led at the Australian National University, looking at the reform of international investment law, with particular emphasis on the European Union's approach. So this is my book, and here are some questions which I look to address in this book. So in particular, I was interested to see how is the European Union, and in particular its legal order, shaping the reform of international investment law. And in this sense, I took a reform in a rather broad terms, so looking at different dimensions of this reform. Then I was also interested to see how is this reform achieving different normative objectives of the global ISDS reform. So focusing on two objectives, the rule of law and legitimacy, and I'll come back to those goals. And I was particularly interested to see how law and politics interact in this sphere of international law. And yeah, here comes the subtitle of my book, Aspirations and Reality. But basically, what I try to do is paint a picture of the complexities and often contradictions that we actually see in this field of international law, but also in many aspects in the EU's approach to the reform. So why this book? Why did I decide to do this research? Well, there were two aspects of it. Of course, the European Union as an emerging actor in the field of international investment, in particular since the Lisbon Treaty of 2009, the new competence that the EU has gained and very ambitious approach to international investment, its international investment policy. And then, of course, in that context, the wider role that the EU wishes to play in terms of shaping international law and global governance. So different normative aspirations of the EU, which we also find enshrined in the EU founding treaty. And then on the other hand, international investment regime, which in itself is an evolving regime of international law. We see constantly new awards. It's also a regime which is so vibrant, but also we see a number of contradictions and tensions there. But what is particularly interesting is this ISDS, Investor State Dispute Settlement Mechanism, that we find in the regime, which serves as a neutral forum for resolution of investment disputes. So in a way, a mechanism which was introduced to deal with, well, to keep politics away from law. But what we have seen is that the perceptions about that regime have been changing a lot. So there's been a lot of public controversy, which started with, of course, the negotiations of the trade agreement with the US in the EU, but also with the main investment cases like the Vattenfall case, here in Australia, the Philip Morris case, and so on. So in a way, we've seen a lot of public interest in international law and different and certainly shifting perceptions about international investment law as being this neutral sphere of international law. So that these kind of things have interested me to see the interactions of the two. And of course, then that comes at a time also when international investment law is reforming. So here, because you're based in Belgium, you will know very well the artist, and you know, in a way, the Tower of Babel in many aspects reminds or symbolizes for me international investment law, and particularly its reform. So combining different tensions that we see, and from these tensions also challenges for the reform. These are political, but also economic and legal. So we see also the particular nature of international investment law, which kind of makes it also difficult to reform it. And of course, different scholars have also been inspired by different symbolism of international investment law. So this is by no means unique, but I think it's interesting. The field is interesting also due to those different tensions. So when we talk about reform, of course, we know this big reform taking place in UNCITRAL since 2017. So it's a long process which is ongoing. But we can talk about reform at also bilateral levels in terms of international investment treaties, regional level, and then within the EU, but also multilateral, and then also substantive and procedural. So on the one hand, reform of ISDS, so the dispute settlement mechanism, but also the substantive reform in terms of investment protections, the substantive protections that are given to investors under treaties. And I think the core question that we see here is really, what is international investment law for? And it's a difficult question. And because it is so difficult to answer it, in a way, the big reform in UNCITRAL does not really focus on that question. And I think that is already the starting problem of the reform. It's the focus on procedural mechanism, because if you look at the political reality, this is kind of easier for states to agree than look at some of the substantive elements. But as I go on, you will see that it's very difficult to divide the two, especially if we look at this regime through the lens of the rule of law and legitimacy. So there are different dimensions of the reform that I then examine in the book. One way is considering that relationship between law and politics. And in this sense, I have taken as a theoretical framework the rule of law as a legal concept and legitimacy as a political concept. And I will explain in a moment why it is important to look at them together. Then the other dimension that I have looked at is EU internal as well as external dimension. So I wanted to see how the two dimensions complement each other, and in a way look at these issues of domestic versus international rule of law and the EU's approach with respect to rule of law internally as well as externally. And very important in the book is really the role of the Court of Justice of the European Union. So I do focus on the three important decisions, the Achmea judgment, the opinion 215 and opinion 217. And in a way, the other case law supports the different principles that have been emphasized in these decisions. And then, of course, I am also interested in the book and looking at EU law versus international investment law. So the relationship between the two regimes, which is also shaped in many ways through the autonomy of the EU legal order. But I think that relationship could be also seen in a bigger picture through the lens of fragmentation in international law and institutional hegemony, which I was inspired here by the work of Martti Koskieniemi, of course. And I think in many aspects, developments between and the interaction between these two regimes kind of demonstrates his theory of fragmentation. So why legitimacy and the rule of law? I think if we look at from the political perspective, there is the lack of legitimacy and legitimacy. I will explain the concept of legitimacy, but there is in a way, legitimacy is not considered important by investment lawyers in many aspects. And I think this is kind of a missed point, because if we don't address legitimacy, the problems will continue. So in a way, I think it's important to combine the two, both politics and law. So although, yeah, we want to keep the regime objective, independent, and so on, we also have to look at the ways in which the public can actually trust the regime, and in that way, these intersections between law and politics have to be addressed. So we have different systemic issues, and I think part of the problem of the reform is that it does not focuses on those substantive injustices that are seen as such by the public. The issues like why are the right to regulate, or why the public interest is subordinate to the interest of foreign investors, And really, that goes again to that core question, what is international investment law for, which we don't really see the answer in the reform. So the focus is on these procedural improvements, which are still important, I believe, but they're not the full picture. Legitimacy, what do I think by legitimacy? So again, legitimacy as a concept can be seen from a more normative perspective and sociological perspective. And in a way, it's very different to divide the line between the two, because we're really looking at different perceptions that subjects have with respect to the institution's right to govern. But there are ways in which, at least at the normative level, legitimacy can be improved with respect to enhancing participation in decision-making of different actors, through improving the quality of the process. That goes into the question of how we address shortcomings of the international investment arbitration, and then, of course, the effectiveness of these decisions, so where we focus more on the investment treaty awards. And then the rule of law perspective, which has often, we focus on those formal and procedural aspects of the rule of law. We look at the characteristics of law and different ways through which the discretion of the decision makers can be limited, and in order to ensure equality as the final outcome. And procedural aspects of it, where we can look at international investment law through the lens of procedural fairness. So in a way, guaranteeing due process to investors, but on the other hand, some of the issues that have been noticed by scholars in terms of procedural aspects of investment arbitration is the questions of institutional bias and the disciplinary bias, which then also affect the legitimacy. But of course, there is, I think, a very important aspect of the substantive rule of law, and the question to what extent is law is neutral, or and who is there to actually set the normative standard, who of that normativity of international investment law, what that standard should be, who should decide about it. And in a way, we've seen that a lot of outcome, that this has been delegated to investment tribunals, and a lot of outcomes that we see are detached from, say, social context, and that is also then impacting, having impact on legitimacy. So one of the important aspects of that substantive rule of law is how do we actually improve the right to regulate? So how do we balance the protections versus the public interest, so private rights protections versus the public interest? So this is just one of the graphs that I use in the book to kind of explain more clearly these complex issues, and to actually demonstrate how legitimacy and the rule of law relate to each other, and how they affect different aspects of the international investment regime. So when we talk about the EU and international investment law, the focus of the book, so this is the second dimension that I look at, is how is the EU approaching that reform? And we see that the EU legal order is kind of defining the interaction between the two. So internally, there is incompatibility between EU law and international investment law. That incompatibility is interestingly jurisdictional. And so that leads to, and that stems from the Achmea judgment, but it leads to elimination of ISDS in the intra-EU relations between the member states and investors from member states. So the idea here is internally, investors should use domestic courts. And while externally, we see that there is compatibility, but the focus is there on more coherence in that external dimension. And then there is this new court, a new institutional instrument, which should ensure that coherence. But I think what is particularly interesting if we look at this relationship is the role of the Court of Justice in legitimizing the policy, so both internally and externally. So if we look at the Achmea judgment and the consequences of that judgment, the idea really, first of all, if you remember that period 10 years ago where we had discussions in the EU about intra-EU dispute settlement and so on, in a way, you've seen those political differences between the Eastern member states and Western member states, one being on the receiving end of the claims. So in a way, the Achmea judgment has served to bridge those political differences and achieve more or less consensus. It's not still perfect, but we have one member state which is which has some different opinions about some aspects of this, but nevertheless, I think the court has had an important role there. And in a way, the emphasis of the Court of Justice was really on enhancing legitimacy of domestic courts. So the focus being placed on mutual trust within the European Union, between the courts in the European Union, and that can be compared to or contrasted to mistrust that ISDS as such, or international investment law as a regime, has in domestic courts. So Achmea, in a way, was the idea of the Court of Justice of enhancing the efficiency of EU law through judicial review. So in a way, making sure that all those inconsistent state measures inconsistent with EU law, which could breach the rights of foreign investors, are actually eliminated from the system. And in the long term, that has impact of, or should have impact on, enhancing the domestic rule of law in the EU. So, but there is focus as well on EU integration. So I think it's very important to look at that judgment in the context of EU integration. And if we look at or think about institutional hegemony, again, one idea of the court here was really to overcome the fragmentation of EU law in a way where the Court of Justice assumes its role as the ultimate authority to interpret EU law. Of course, that has had the impact on international law, and we've seen the different issues stemming from Achmea in terms of enforcement of investment, of intra-EU investment awards. So in a way, yeah, maybe the idea is to overcome fragmentation internally, but it's really externally, it is creating a lot of problems, and then you could also say it undermines the rule of law on the other hand in terms of enforcements outside of the EU, because it creates a lot of uncertainty. And then I think one important aspect, so that's internal aspect. The external aspect is looking at the EU international investment policy. Again, I think the Court of Justice has played a very important role in defining the policy scope here. And in many aspects, this limited EU's investment treaty-making sovereignty that stems from Opinion 215 has, in many aspects, undermined the whole policy, because it has it's in terms of practical consequences, it's very difficult for the EU now to conclude international agreements which have ISDS because of the shared competence. So all member states have to ratify that those agreements, and there are obviously stumbling blocks there as well. But you could also look at it whether that has led to more legitimacy, in a sense that now we have greater involvement of member states, and although in terms of efficiency it's not ideal, there is more at least legitimacy and in a way democratic processes enhanced with all these national parliaments being part of the international investment policy. But in terms of efficiency, definitely this has been a problem, and it has weakened the EU's international investment policy. But again, I think just coming back to the issue of domestic courts, obviously courts are the core of member state sovereignty, and this kind of comes through as well in the opinion 215. So I think the EU international investment policy, and this is my argument also in the book, it can really be seen as expression of the rule of law, the EU's expression of the rule of law, combining the EU's also geopolitical interests. So in a way, ensuring, so there, we cannot just eliminate ISDS externally because there is a need to protect EU investors abroad. The EU has to be competitive compared to third countries, so compared to also the US and Chinese investors that have this kind of protections in third countries. So the EU's approach to the external dimension is then establishing a multilateral investment court. Well, first stage is the EU's bilateral agreements and investment court system, but we have to look at this in a long-term vision of a multilateral investment court. And this court is then to ensure more coherence in the EU external policy, because it should gather different bilateral agreements of the EU, but also ultimately of the member states. And we have to really, if we think about the external dimension of the EU international investment policy, it goes hand in hand with member states' bilateral investment treaties. And there are over 1,200 member states bilateral investment treaties. So in a way, how do you ensure coherence? Ultimately, hopefully, multilateral investment court can kind of be the mechanism for settlement of these disputes under these different agreements. That's an aspiration and a long-term one. So we can discuss whether that can work or not, but this is kind of a way of the EU's approach of ensuring that rule of law externally. And I think this, again, that aspirational internal and external coherence can be also seen with respect to the Court of Justice's focus on the right to access to an independent tribunal, under which is guaranteed under Article 47 of the Charter of the Fundamental Rights, EU's Charter. So obviously the criteria for internal and external right are not the same, but that right is in a way also to be ensured in the future multilateral investment court. Well, these are at least conclusions that we can draw from opinion 117, which has assessed the compatibility of CETA and the investment court system with the EU law. But mind you, in principle, there is compatibility, but we might have to have another opinion if the court is established one day to actually see to what extent that court will be compatible, because one of the important aspects of the CETA assessment was also the emphasis on the improvement of substantive standards, which we find in EU agreements. So in a way, the court has looked at those standards in combination with the right to regulate, and concluded that public interest will be sufficiently protected under the CETA. So that's of course, conclusions can be drawn with respect to MIC, but it is going to be a different type of mechanism ultimately. So again, coming back to the legitimacy and the rule of law in the context of the EU reform, yeah, we can look at the different aspects of improving legitimacy with respect to EU investment agreements, then that procedural aspects of the rule of law and throughput legitimacy through the multilateral investment court, and then ultimately the substantive elements with multilateral investment court achieving more consistency and predictability, more coherence with respect to its outcomes, but also in a way political acceptability through the mechanism of binding interpretations by contracting parties. So emphasis more on having more control of states over those outcomes. So I will finish with another, well, this is the cover of my book, and maybe now it becomes clear why I have chosen this cover. But in a way, this beast is representing the different aspects of EU reform and the difficulty of really finding a consensus, and that difficulty, of course, continues with respect to the UNCITRAL reform, and then the princesses in the background. You can think of the international investment arbitration, the establishment of international investment law, looking at this beast and thinking what will happen with it and how will everything end. But in a way, when we think about reform of international investment law, we really see emphasis on different visions of the rule of law in international investment law. So this is one of the EU's vision concerns the new court, the independence of that court, enshrining those rights. But there are also other visions for investors. That vision is surely ensuring protections against state interaction, interference with their rights. For smaller states, it's a choice between different visions of the rule of law by big states. And of course, some states emphasize the enforceability and the effectiveness of the current system in terms of protection. So the rule of law through enforcement and looking at that international investment law as more a commercial part of the activities rather than just necessarily focusing on the public aspect. So in a way, we'll see in the system, a system will remain fragmented in many ways and complex, and of course it remains to be seen what will be the outcomes of the UNCITRAL reform. I'll stop there so that we can actually have a bit of a discussion. Thank you.
Thank you so much, Ivana. This is a really wonderful overview of your book, and I also am looking forward to picking this up soon. And now we'll turn directly over to you, Matthieu, for kicking off the discussion. But I would like to just remind the audience that you can send your questions for Ivana via the Q&A feature at the bottom of the Zoom window. So please send those in, and over to you, Matthieu.
Thank you very much, Carrie, and many thanks to the GGS for inviting me to act as a discussant in this seminar. So first of all, I mean, I can only warmly recommend, I mean, our audience to read the book. It's, I think, a very timely book that deals with a number of highly relevant issues that go from the legitimacy crisis of the global investment regime to challenges of effectiveness of the European approach to international investment law. So definitely a book that I would recommend to practitioners, academics working in the field, but for also people who teach in that area. I mean, definitely a book that you should add to your reading list. So the book really starts, I believe, with a strong case in point in favor of reforming the global investment regime. But I think that Ivana does that in a very balanced way. And I think it's this kind of balance that is very often missing when looking, let's say, at the history and current developments of the global investment regime. And I think there is a very strong balance that has been found there, and a balance that is very much based on what I would call a very strong theoretical framework. I mean, the ways in which rule of law is being linked to input, throughput, and output legitimacy, I think definitely very much strengthen and very much substantiate the argument that is being made in the book. Last but not least, for EU lawyers, I mean, the book also provides a very good summary and critical analysis of developments that have taken place within the EU, and indeed linking them to the developments in the area of the EU's common commercial policy. So in the coming minutes, I just would like to make a few comments relating to what I think are important areas that are kind of presented in the book. Then I would like to draw some parallels with a topic on which I've been working on, that is the Comprehensive Agreement on Investment between the EU and China, which is, I think, a good illustration of the current state and also the kind of challenges that the European approach to international investment law is actually facing. And last but not least, I will just share 2 or 3 questions that you may want to pick afterwards, Ivana. So first of all, I think the first issue that I would like to highlight is, I mean, the strong appeal that is made in the book for a comparative approach to international investment law. And here, I think your book very much resonates well with the book of your other colleague at ANU, I mean, Anthea Roberts, and her seminal book is International Law International. Because I strongly believe that if there is one area of international law in which we cannot avoid having or shedding light on this comparative approach, it's definitely international investment law that you characterize as one road with many directions. And those many directions have been very prominent from the very early days, right, of international investment law, with the strong distinction that has the very distinct approaches that have always characterized the approaches of host states or home states to foreign investments vis-a-vis international investment law. I mean, historically, indeed, I mean, the strongest criticisms have usually emanated indeed from the so-called global south, right? Where in the early days of the international investment law, there was this idea of the need to protect the right of the state to regulate, and in particular, the need to protect state sovereign rights to manage their natural resources in particular. But again, still these days, in a context in which we do see many BITs and investment agreements between countries from the global south, right? We are no longer talking about this kind of unidirectional type of relationship between the global north and the global south. We also indeed witness strong calls indeed to protect the right of the state to regulate, also through the adoption of a more restrictive enterprise-based definition of investment, something that you find, for instance, in the India model BIT, but indeed strong calls to get rid of umbrella clauses such as the MFN provisions and others, which are typically included in investment agreements. Here, what is quite interesting is indeed this idea that the EU is a little bit of a newcomer, right, in that debate. I mean, we are really talking here about a kind of post-Lisbon type of development. And the book very well sheds light on the on the very distinct approach that the EU has endorsed post-Lisbon, in contrast or in opposition to what EU member states were doing in the past, right? I mean, an approach to international investment law that is indeed very clearly connected to a commitment to reform the traditional investor-state dispute settlement mechanism, with first the introduction of this investment court system, and indeed, I mean, the ongoing negotiations or the ongoing mandate that the European Commission has to negotiate the establishment of a multilateral investment court. But also in the EU context, this idea that the EU's engagement with international investment law shall indeed comply with the foundational values of the European Union, and in particular, all those values, objectives, principles listed in Article 21 of the Treaty on the European Union, including rule of law, human rights, and also sustainability, and one that we actually very often forget about, which is the principle of solidarity. I would actually add to that one element on which I would like to come back during the Q&A, that is the importance of unilateral instruments of economic law that have become increasingly prominent in the EU's approach to international investment law, with indeed a strong emphasis put on the introduction of foreign investment screening mechanisms in different EU member states. I think now it's all 27 EU member states that are considering, or indeed who have already established a foreign investment screening mechanism. The second element that I would like to emphasize is indeed the importance of politicization of international investment law. And by politicization, there is this idea of strong polarization, right, of opinions, interests, and values that relate to the EU's engagement with international investment law, something that we saw very much emerge around the discussions around the TTIP, right? But then indeed CETA, where indeed we saw that parliaments, being the EU Parliament, but also national and in particular subnational parliaments, had indeed become very important voices in the context of the EU's common commercial policy. And here I just would like to relate back to this so-called Namur Declaration, which was released by the Walloon Parliament, which was a little bit the troublemaker, I mean, in the background of the CETA, with indeed strong calls for the EU to respect, I quote, democratic procedures, comply with socio-economic, sanitary, and environmental legislations, bearing in mind that a big part of the criticism at the time was around the principle or the practice of ISDS in particular. Again, in the context of this politicization, there is indeed the big question of what is the role of the state, right? And here there is this tension between the public and the private role of the state, between contractual freedom on the one side and the right to regulate on the other. Or to quote an article of Katarina Titi, which has been recently published, this idea of a tension between private law and public law, which are indeed two areas which are very much prominent in that area of practice. And in a way, actually, for the French or continental lawyers in the room, I mean, it's one of those areas in which we are forced as either private or public lawyers to speak to each other. And this is definitely one of the benefits, I would say, of international investment law. A third point that I would like to emphasize is indeed issues of coherence and the implications of EU institutions working very much in silo. That is to say that they have, I mean, their own turfs, right? The Commission does their own things, the Parliament, the Council, and indeed a coherence in that context can be sometimes seen as a kind of burden, right? And which obviously also has strong implications for the actual effectiveness of the EU's approach to international investment law. Last but not least, the fourth element, which I think is very important in the book, is that at the end of the day, I mean, what is more important in the current debate does not relate that much to the ability of states or the EU to attract more foreign investment flows, but the big question is who will be able to set the rules. And again, the engagement with international investment law, I mean, does testify to this regulatory race in which the EU is an important part of. Question of the Brussels effect, right, which is now very much in opposition with what some would call the Beijing effect. And again, this tension as to who will be able to shape the institutions at the heart of the global governance architecture and who will be able to shape reform or create new rules of the game in that context. As I said earlier in my introductory remarks, I believe that the comprehensive agreement on investment between the EU and China, I mean, is a nice illustration of many of the points that you raised in the book. So just as a kind reminder, we are talking here about an agreement which was concluded in principle back in December 2020, and which has now been put in the fridge or in the freezer, depending on how optimistic you are on the actual fate of that agreement. Agreement whose very conclusion and ratification has been very much politicized. There have also been significant issues relating to the legitimacy, including the question of the legitimacy of the mandate of the European Commission to negotiate with its counterpart in China, bearing in mind that the mandate was provided back in 2012, and that indeed China had very much changed, right, when the agreement was signed finally in December 2020. An agreement which also demonstrates the very lack of consensus on ISDS reform, in the sense that the text of the CAI, as it was concluded in December 2020, did not include any proper enforcement mechanism, investor protection mechanism, right? There was this idea that the EU and China would keep negotiating, I mean, a proper way to resolve their investment disputes. Which also had, I mean, a significant effect, because indeed not having ISDS in the agreement meant that the agreement was no longer a mixed agreement, which was actually a big surprise to national and subnational parliaments, because the message of the European Commission throughout the negotiations was very much, it will be a mixed agreement and you national and subnational parliaments will have a word to say here. To kind of perception in the Walloon Parliament was back in the days, great, we'll be able to speak about human rights in China, I mean, when discussing the agreement, but indeed the approach was then very much different. Another point that makes, I believe, the CAI quite relevant, it actually shows the importance of BITs adopted by member states, which remained very much relevant, right? In a context in which it is still very much difficult for the EU to conclude EU-wide investment agreements, bearing in mind that even if now that the CAI has not been ratified, the EU member states BITs with China remain valid. And by the way, all those have very much old style, I mean, old generation type of BITs that rely on traditional ISDS, do not make any reference to environmental protection, do not make any reference to labor rights, and so on and so forth. So these are different elements which I believe make the CAI quite prominent. I see that we are running out of time, so I will moving on to my questions, if that's fine, Carrie and Ivana. So 3 questions, if I may. The first one is indeed relates to the interaction between the bilateral instruments, but also the EU's engagement with the multilateral investment regime, with indeed the toolbox of unilateral instruments that the EU has. That is to say that in parallel to all those dynamics that you describe very well in the book, what you do see is that the toolbox of unilateral instruments of international economic law at the disposal of the EU has become increasingly comprehensive. And the best illustration thereof is indeed the introduction of the EU investment screening mechanism back in 2017, but indeed also the introduction of its equivalent at the member states level. So how does it play out? I mean, the interaction between those different instruments. Then the second question would be, against the background of a very fragmented global investment regime, to what extent would you say that the interaction between a multiplicity of legal orders, international, EU, national legal orders, would indeed lead to the emergence of what you could call constitutional principles in global economic governance? So I guess that in your answer, you will touch upon the rule of law, but also maybe beyond that, what would be the kind of constitutional principles that may kind of emerge out of the interactions between those different legal orders? And the third question, which is actually a question that kind of came into my mind when listening to you during your presentation. When you read the literature on rule of law promotion within the EU and also in the EU external action, there is very often a tension between what the EU does internally, that is to say, rule of law promotion within the EU itself, and on the other side, the promotion of the rule of law in the context of the EU's external action. So I just wondered if those tensions also exist in the context of the EU's engagement with international investment law, and if you could kind of give a couple of examples of the tensions that you may have encountered in your research. So just a few questions. You may not have time to pick them all, but just some food for thought for the Q&A now. Thank you again, Ivana.
Ivana, we'll turn back to you really quick, but I just wanted to let the audience know we did get started a couple minutes late. So if everyone is okay with it, Ivana and Matthieu, if we can go maybe 5 minutes past. Is that fine? Okay, great. Then over to you, Ivana.
Thank you. And thank you, Matthieu, for this reflection, which I think it's very good and adds a lot to everything what I have been saying about themes of the book. I think very interesting your question about unilateral instruments. I start with that because I think these unilateral instruments kind of have to be again placed in a bigger picture of changing global environment. So, even if we think about the core freedoms in the EU, free movement of capital, now we all of a sudden have a screening of foreign direct investment and kind of additional limitations on that freedom, although yeah, we can discuss to what extent that freedom is really freedom, but it's an interesting element. And in a way, I think that also demonstrates that the appetite for EU's international investment policy has also changed. The policy is more reacting to the needs of the member states as well, because obviously the mechanism was included as a reaction to or demand from certain member states, and in a way it's creating a new area of EU law. And I don't think that investment court system is anymore a priority, or investment protections. They're not really a priority anymore in the international policy of the EU. The UNCITRAL process is ongoing. The reform should finish in 2026. In the best case scenario for the EU, there will be a court established. We really don't know, but that's the best case. And then there will be additional process in terms of operationalization of the court, additional meetings, and so on. So this will take some time, and and I think in many aspects, while this is taking place, on the ground, yes, we have investment screening mechanism. We have different mechanisms in terms of also promoting sustainability in EU's trade relations, which complement as well different developments in the investment area. And we also see the shift in EU's agreements. So yeah, we have obviously 5 agreements that have implemented the new investment court system, but now we have the new facilitation agreements, investment facilitation agreements with Africa, for example, where the focus has shifted from dispute settlement to investment governance and state-to-state relations, and improving investment climate, and making sure that it's more transparent, that different problems are quickly resolved on the basis of law, and so on. So, and shift from a dispute settlement in a way to a dispute resolution, where diplomacy becomes more important than this traditional investment dispute settlement that we've seen between investors and states. So I think, and of course, we still have member states investment agreements, and they will continue. They will continue for the time being, and in a way, it's business as usual, because the investment policy of the EU is enshrined in the treaties, agreements that are not in force. And So we don't really know how the system will operate. And of course, the multilateral investment court is not there either. So I think these developments kind of are pragmatic in many aspects as well, in terms of unilateral instruments, and also a way that the EU is reacting to global developments, because other countries also have screening mechanisms in place. And so that's I think one thing. Now, in terms of the constitutional principles, in that sense, I think it will be difficult to, even if we have a multilateral investment court, think about coherence of international investment law, because arbitration will still be there as an option for investors. So we might end up with having more fragmentation in many aspects. But I think if we think, and one way of thinking about this is to see how is the Court of Justice of the EU thinking about investment court system, and we can look at that in the context of opinion 117, and this also goes into your third questions regarding the tensions of the rule of law. So in a way, I think the court system can be a better mechanism for developing different constitutional principles. And it will be important that right to regulate, and in particular emphasis on sustainability, will be important to be included as one of the principles. So it also goes back into the values that you mentioned at the beginning, and Article 21 of the EU. So basically, it will be important that the new mechanism really implements also sustainability through the right to regulate. And I think the way that the Court of Justice thinks about it, it's more and about the right to regulate. It really goes more into the traditional way of thinking about sovereignty in international law, and in many aspects emphasizing the role of the states and that with that the right to regulate. Tensions, yeah, definitely the rule of law, as you know, we examine it internally and externally. In terms of at least the investment court system, we can see already that in a way the court has lowered that standard for the investment court system, in many aspects saying, well, this is, you know, work in progress. So we still have things to address that will need to be addressed. But in many aspects, that rule of law is different. And in chapter 9 of the book, I really question to what extent, you know, we already could not talk about the right to access to an independent tribunal in the context of what we have at the moment with investment arbitration. You know, I think it's not really easy fully to demonstrate how the court is going to address some of the issues regarding independence and impartiality. So there, I think, you know, a lot will depend on who will sit on the court. We don't know that yet. The EU, again, you can see how the EU exports its way of thinking. So one of the ideas is to have a selection committee, which would be similar to the selection of the judges in the Court of Justice of the EU. So to have something like that in that multilateral investment court, so to ensure really a more diverse views that can then not just look at these issues through the prism of protection of foreign investors, but actually having a more balanced approach in terms of ensuring that, yes, investors' rights are protected, but that they can also be limited by the government action, and that there has to be a proportionality, something that we actually see in constitutional systems where, you know, the rights are not absolute. So in this sense as well, they should not be absolute in investment regime. They're not, but the way that the balance is established at the moment, in many aspects, it prefers investors' rights to the on the account of public interest.
Thank you so much, Ivana. We don't have much time for questions, but you did answer in your last discussion a question that we had from the audience member about the multilateral investment court and further fragmentation. So I think we already covered that. So hopefully the attendee has gotten an answer to that. And then also we did discuss a little bit investment screening. So hopefully the question on OFAC is also somewhat covered. So we'll just ask one question, if you don't mind. You noted in the beginning that there is no consensus as to the very purpose of investment law and investment law reform. And so based on your experience, both in politics and also in academia, I was wondering if you had an answer to this question yourself of what the purpose of investment law, its reform, should be.
That's a very good question. Yeah, I think as always, and it goes back also to some of the issues that we have discussed. I think there has to be a balance between protection of foreign investors and public interest, because if we don't establish that balance, if the investment awards don't also reflect in many ways the domestic context and the preferences of particular domestic regimes, then we do have a problem of perception about the regime. So I think there is a value in having this system, although I think the reform has to go much further to perhaps more look at the protections to foreign investors which we have under customary international law, and limiting more those protections. But yeah, the substantive protections also go hand in hand with the dispute settlement mechanism and who decides about the scope of those protections. So that kind of brings the need to address both, and that makes the exercise quite complicated, but possible.
Thank you very much. That is unfortunately all the time that we have for today. This has been a very interesting discussion. So thank you both, Ivana and Matthieu, for taking part in this, and all of you in the audience for joining today's webinar. Before leaving you, I would just like to announce that our next webinar is on the 14th of November, and this will bring in Professor Rebecca Perlman to discuss her book on regulating risk, how private information shapes global safety standards. And then in December, Professor Cornelia Wohl will join us on corporate crime and punishment, her recent book on that. You can sign up for those, as always, at eu-renew.eu. But thank you again, Ivana. Thank you, Matthieu, for joining us today. It's been a real pleasure.
Thank you. Bye.
See you next time. Bye.